Hi there, and welcome to this video on how to get a divorce in Texas. My name is Lena Wynn, and I'm a divorce attorney based right here in Texas. If you're watching this, you or someone you know might be going through one of the most difficult times in life, the process of getting a divorce. It's emotional, stressful, and sometimes overwhelming, but understanding the legal process can help make it easier to navigate. Before we begin, the information provided in this video is for educational purposes only and does not constitute legal advice. Viewing this video does not create an attorney-client relationship. For advice specific to your situation, please consult with a licensed attorney. In this video, we're going to break down everything you need to know about divorce laws in Texas. Whether you're just beginning to consider divorce or you've already started the process, this guide will give you the clarity you need. We'll cover the basics of Texas divorce laws, the grounds for divorce, residency requirements, and why having legal guidance is crucial during this time. Now, I know that thinking about divorce can bring up a lot of emotions, confusion, fear, and even guilt. It's perfectly normal to feel this way. And while the legal process may seem daunting, it doesn't have to be if you have the right information and support. Let's start with an overview of divorce laws in Texas. Texas operates under what's known as no-fault divorce laws, meaning you don't have to prove that your spouse did something wrong in order to file for divorce. But there are also fault-based grounds for divorce, which we'll explore in just a moment. Texas divorce laws focus on several key areas, including division of property, child custody, child support, spousal maintenance, also known as alimony, and sometimes issues like restraining orders or spousal abuse. Understanding these areas will give you a good idea of what to expect and how Texas law approaches them. Let's start with the most common ground for divorce in Texas, no fault. As I mentioned earlier, Texas is a no-fault state. What this means is that you don't have to prove that your spouse did something wrong, like cheating or being abusive, in order to file for divorce. In a no-fault divorce, you can simply state that the marriage is insupportable because of a discord or conflict of personalities that prevents the reasonable expectation of reconciliation. In other words, you and your spouse no longer get along and there's no chance of getting back together. Now let's think about this practically. Let's say you and your spouse have simply drifted apart over the years. There's no abuse, no affair, just two people who no longer share common ground. In this case, a no-fault divorce would be the easiest and quickest option. On the other hand, Texas also allows for fault-based divorce. This means you can file for divorce based on specific actions your spouse took. If a fault ground is proven, it can influence important decisions in the divorce, such as property division, spousal maintenance or alimony, and child custody. Let's break down the main fault-based grounds in Texas law. There's adultery, cruelty, which includes physical or emotional abuse, abandonment, conviction of a felony, and living apart for at least 3 years. Adultery is defined as one spouse engaging in a sexual relationship with someone outside of the marriage. In Texas, this is one of the most common fault-based grounds for divorce. What you need to prove. To use adultery as grounds for divorce, you must provide evidence that your spouse had an extramarital affair. Evidence can include testimony, photographs, text messages, emails, phone records, or even admissions from the spouse themselves. Why it matters? While Texas is a no-fault divorce state, proving adultery may have an impact on the outcome of your case. For instance, in property division, the court may consider the behavior of the spouse who committed adultery. Additionally, if adultery is proven, it can affect spousal support, as the spouse who committed the adultery may be seen as less entitled to maintenance. Now, here's a real-life example. Imagine a spouse who finds out their partner has been in a long-term affair. They gather evidence such as text messages, photographs, and a confession from the cheating spouse. Filing for divorce based on adultery may make the process more contentious, especially when it comes to dividing assets, and potentially result in one spouse being ordered to pay higher spousal support. Now, cruelty refers to any behavior by one spouse that causes physical or emotional harm to the other spouse. This can include physical abuse, such as hitting, slapping, or any form of physical violence. It can also include emotional abuse, such as name-calling, intimidation, threats, humiliation, or any behavior that damages the emotional well-being of the other spouse. To prove cruelty, you need to show that the other spouse's conduct was not just disagreeable, but was harmful enough that it made living together insupportable. Evidence of cruelty can include police reports, medical records, photographs of injuries, witness testimonies, text messages, or even audio or video recordings. If cruelty is proven, it can significantly affect the division of property and spousal maintenance. The spouse who committed the cruelty may be less entitled to an equal share of the marital property, and the court may also grant higher spousal maintenance to the victim of the cruelty due to the emotional and psychological toll. Here's a real-life example. A spouse who is physically abused and has to seek medical treatment may be able to use medical records, witness testimony, and police reports to prove cruelty. The court might order the abuser to pay for counseling or therapy for the victim, as well as a larger share of the property division. Abandonment occurs when one spouse intentionally leaves the marriage with no intent of returning for a specified period of time, usually 1 year or longer. The spouse who left the marital home must have made the decision to leave, and there must be no reasonable justification for the abandonment. To prove abandonment, you must demonstrate that the spouse left the marital home without your consent, without providing for your needs, and with the intent to abandon you. If your spouse has left for over a year, you may be able to use abandonment as grounds for divorce. Abandonment can impact property division in a divorce. The spouse who left may have a more difficult time claiming a fair share of the marital property, as their abandonment is seen as a contributing factor to the dissolution of the marriage. Abandonment can also be used to argue for more favorable custody arrangements, as it shows a lack of commitment to the family unit. Now here's a real-life example. Imagine a spouse who decides to move out of the house and live in another city without communicating or providing any financial support for the family. If the abandoned spouse can show that the abandonment has lasted over a year with no intent to reconcile, this may be used to file for divorce under this fault-based ground. Conviction of a felony. If one spouse has been convicted of a felony and is either sentenced to prison for at least 1 year or serves a prison sentence for a felony conviction, the other spouse may file for divorce based on this ground. This ground is relatively straightforward. You must show that your spouse was convicted of a felony and served sentence for at least 1 year in prison or served time for a felony conviction. You will need official records for the conviction and sentencing. So why does this matter? A conviction of a felony can have a significant impact on the court's decision regarding property division, custody, and even spousal support. The spouse who has been convicted may be seen as a less favorable party in the divorce, particularly if their conviction resulted in a long prison sentence. It may also influence how the court handles child custody matters, as a felony conviction may be used to argue that the convicted spouse is unfit to care for the children. Here's a real-life example. Imagine a spouse who has been convicted of embezzlement and sentenced to 5 years in prison. The other spouse may file for divorce based on this conviction and seek a more favorable property division, as well as increased custody of the children. The conviction may also affect the ability of the incarcerated spouse to receive spousal maintenance, as their ability to earn income may be severely restricted while in prison. Living apart for at least 3 years. In Texas, if the spouses have lived apart for at least 3 years, one spouse may file for divorce based on this ground. This ground doesn't require proof of fault or any specific behavior. It simply recognizes that the couple has been living separate for a long period of time. What you need to prove. The only thing you need to prove here is that you and your spouse have lived in separate residences for at least 3 years without living together as a married couple during that time. No formal legal separation is required, but you need to show that there's been no cohabitation during that period. Living apart for at least 3 years is often used as a ground for divorce when both parties agree that the marriage is over but don't want to argue over specific details. It is a less contentious fault-based ground than adultery or cruelty, but it can still impact how the divorce is handled, especially in terms of property division and spousal support. Now here's a real-life example. A couple who has been living in separate homes for 3 years with no contact or attempts to reconcile. They may use this as a ground for divorce. The court may take into account that they've been separated for a prolonged period of time and that reconciliation is unlikely, leading to a relatively straightforward divorce. Each of these fault-based grounds for divorce in Texas requires specific proof and may have varying degrees of impact on the overall divorce process. While fault-based divorces can be more complex and emotionally challenging, they can also result in more favorable outcome in terms of property division and spousal maintenance if the grounds are proven. Residency requirements for divorce in Texas. Texas, like many other states, has specific residency requirements that must be met before a person can file for divorce in the state. These requirements ensure that the Texas courts have jurisdiction over the case and that the legal proceedings are conducted fairly. So let's break down these requirements and understand the details. Number 1, minimum residency. To file for divorce in Texas, either you or your spouse must meet certain residency criteria related to how long you've lived in the state. Specifically, the filing spouse, the one who initiates the divorce, must have lived in Texas for at least 6 months prior to filing for divorce. Why does this matter? Well, the residency requirement ensures that Texas has jurisdiction or authority over the divorce proceedings. If you or your spouse have only recently moved to Texas and have not lived in the state for at least 6 months, you will need to wait until you meet this requirement before filing for divorce in Texas. Now here's a real-life example. If you and your spouse moved to Texas only 2 months ago and you want to file for divorce in Texas, you will have to wait until you have lived in the state for a full 6 months before your divorce can be legally processed. Residency requirement for the county. In addition to the 6-month residency requirement in Texas, you or your spouse must also meet a county residency requirement. This means that you or your spouse must have lived in the county where you plan to file for divorce for at least 90 days before you file your petition. Why does this matter? The purpose of this county-specific residency requirement is to ensure that the court handling your case is located in the right jurisdiction. Texas is a large state with many counties, and this requirement prevents someone from filing for divorce in a county where neither they nor their spouse lives, which could cause undue inconvenience or confusion for the court system. So here's a real-life example. Let's say you've been living in Houston for 5 years, but you recently moved from a small town in East Texas. If you want to file for divorce in Houston, you or your spouse must have lived in Harris County, where Houston is located, for at least 90 days before filing. Even though you've been in Texas for longer than 6 months, you or your spouse would still need to meet the 90-day requirement for the county. Now, there are special circumstances for military personnel that you need to know. For military personnel stationed in Texas, the residency requirements are somewhat different. If either you or your spouse is in the military and stationed in Texas, you may file for divorce in the county where you are stationed, even if you haven't lived in Texas for the full 6 months. The military member may be stationed in Texas, but may not be a permanent resident of the state. The non-military spouse can file for divorce in Texas if they meet the county residency requirement of 90 days, even if they haven't been in the state for 6 months. Military spouses can also file in Texas if they have been a Texas resident for at least 6 months, but this is less common. The special rules for military personnel ensure that service members and their families can file for divorce in Texas without waiting for long periods, even if they are temporarily stationed there. This rule also recognizes that military families may frequently relocate, and it ensures that they don't need to return to their home state to file for divorce. Now here's a real-life example. Imagine a service member stationed at Fort Hood, Texas, who has only been there for 3 months but is planning to file for divorce. Even though they haven't lived in Texas for 6 months, they can still file for divorce in Texas due to their military stationing. Jurisdiction of Texas courts. In addition to residency requirements, Texas law requires that the court you file your divorce in must have jurisdiction over the case. Jurisdiction refers to the authority a court has to hear a particular case. As mentioned, the court must be in the county where you or your spouse have lived for at least 90 days. If both spouses live in Texas, the case will typically be filed in the county where either spouse resides, as long as the 90-day and 6-month residency requirements are met. Now, if one spouse lives outside of Texas, the court may still have jurisdiction, but other factors may come into play, such as the location of property or children involved, when the other spouse lives out of state or in another country. It is also possible to file for divorce in Texas if your spouse lives out of state or even out of the United States, as long as you meet the residency requirements outlined above. However, the case may be more complicated when one spouse is out of state or out of the country, especially when it comes to issues like property division and child custody. Even if your spouse is living elsewhere, you can still initiate the divorce process in Texas as long as you meet the 6-month and 90-day residency requirements. However, if your spouse is not in the United States, serving them divorce papers can be more complicated and may take longer. International divorces often require additional legal steps and coordination with foreign governments. Here's a real-life example. Let's say you live in Texas and your spouse moved to another country for work. You can still file for divorce in Texas if you meet the residency requirements, but serving your spouse with divorce papers will require additional steps. This might involve international service of process, which is a legal procedure for delivering divorce papers to someone outside of the United States. No residency requirement for annulments. It is important to note that annulments are different from divorces. In Texas, annulments do not have the same residency requirements. While you still need to meet certain conditions for an annulment to be granted, such as proving fraud, underage marriage, or lack of consent, the residency requirement for filing an annulment in Texas is only 30 days in most cases. Filing a divorce in another state. If you're not a Texas resident, but your spouse is, or you've lived in Texas for a significant amount of time, it is possible to file for divorce in another state. However, if Texas law is more favorable to your case, you may want to file here. For example, Texas courts may be more favorable in dividing certain assets, dealing with spousal maintenance, or deciding on child custody. Here's a summary of residency requirements for divorce in Texas. To file for divorce in Texas, the general residency requirements are: you must have lived in Texas for at least 6 months prior to filing. You or your spouse must have lived in the county where you plan to file for at least 90 days. And if either spouse is in the military, there may be special rules about where and when you can file for divorce. If your spouse lives in another state or country, you can still file for divorce in Texas, but there may be added complications. Meeting the residency requirements is the first step in the divorce process. Understanding these rules will help ensure that your divorce case is filed correctly and in the appropriate jurisdiction. If you're unsure about whether you meet the residency requirements, it's important to consult with a divorce lawyer who can guide you through the process. This way, you can make sure that your divorce proceedings are handled properly, regardless of whether you or your spouse lives. Now let's talk about why it's essential to have legal guidance during the divorce process. Divorce isn't just about ending a marriage, it's about making decisions that will affect the rest of your life for years to come. Whether it's dividing your property fairly, deciding on custody arrangements, or making sure you're entitled to spousal maintenance, having a lawyer can help ensure that your rights are protected. Divorce laws can be complicated and they vary from state to state. In Texas, we have our own unique laws and procedures, which is why it's important to have someone who understands them guiding you. A lawyer can help you understand the legal documents you'll need to file, negotiate settlements, and represent you in court if necessary. And if there are children involved, a lawyer can help ensure that custody and child support decisions are made in your children's best interest. The decisions you make today will have lasting effects. Don't try to navigate this alone. To recap, here's what we've covered. Texas divorce laws offer both no-fault and fault-based divorce options. No-fault divorce means you don't need to prove any wrongdoing, just that the marriage is insupportable. Fault-based divorce includes grounds like adultery or cruelty, which could impact the division of property or spousal support. And before you file, you must also meet residency requirements, 6 months in Texas and 90 days in the county. And most importantly, having legal guidance is crucial to ensuring your divorce process is handled correctly. I hope this video helped clarify some of the important aspects of a divorce in Texas. Remember, your situation is unique and seeking the right legal advice is essential. Thanks for watching and stay tuned for the next video where we'll dive into property division and spousal support. Take care and remember, you're not alone in this.